they found him 100% liable, even though he was struck by a Jeep going the wrong way on the highway. And every single case we have now, they want to see the qualification file, the drivers, to look for any little thing. Right.
Welcome to The Defense Never Rests with Morgan and Akins, your monthly dose of uncommon sense about all things legal and some that are not.
Hi everyone, welcome to this special episode of The Defense Never Rests. We are doing things a little differently today. We are at the TITA conference in Philadelphia, and we have a podcast booth set up in the exhibit hall. And our plan here today is just to grab people, pull them on the podcast, and do little mini interviews, and really get to know everyone who's at this conference. So wish me luck, and we're going to just go get some people. Shimon, thank you for joining us at the Defense Never Rests at the TITA conference, the annual conference in Philadelphia. The first time we've ever done a podcast booth at a conference. You are our second contestant to sit down and join me, so thank you.
I feel honored and privileged to do this.
So,
because right now I'm in the top 2 of all people who've actually participated.
At a conference. We have about almost 100 episodes under our belt. So
but it also means I could be second to last or second to worst. So.
Also possible. So you are an attorney out of Chicago, is that correct?
I'm an attorney in Chicago at a firm called LaBarge, Campbell, Lyon, and Cahan.
Okay.
The firm started in 1997, but I just brought my practice there in the middle of the pandemic on January 1st of 2021.
Oh, that was an interesting move. How did you come about to do that? Like, were people scared to move to a new firm in the middle of pandemic?
So one of the disadvantages is not even being able to meet everybody in the firm for several months. There are still a few people I've not actually met in person, but the 3 other named partners, I worked with them at a firm called Williams Montgomery and John in the 1990s. And then I started my own firm with 4 people where I practiced for 20 years. And for a variety of business reasons, it necessitated a change to the new firm. But I've known the 3 principal other partners, named partners at least, for decades. And we've been competitors, but friends.
Oh, great. So I ask this of a lot of my guests, whether they're attorneys or in claims, because everyone has a little bit of a different story. And how did you decide to go to law school? A lot of people, like, their parents were lawyers. Other people decided when they're young they want to be lawyers. Other people just were poli-sci majors and didn't know what else to do. What's your story?
So first, no lawyers in the family. I come from a very, very quick story. My dad was offered a scholarship to Northwestern pre-med and wouldn't go, because he thought he was going to be a token at the time in the late 40s.
Yeah.
And he dropped out of engineering school 6 months without a degree to go work in Israel.
Wow.
During undergrad at the University of Illinois, I participated in 2 mock trial tournaments at Drake University. And we worked with a professor who was an advanced persuasion teacher, and he was testing out his theories. And we were simply the conduit for testing. And we may not have been the most polished, but we won every case based on the merits of the case. And after doing that twice, I just loved litigation.
Yeah.
And so I looked for that specifically for opportunities when I was an undergrad. And that's what brought me to law school later on.
I like that path. See, I ended up in litigation by accident. It was the only jobs that were available. It was the only jobs that were available when I graduated law school. So, and now I know it's like it was the best choice for me in the grand scheme. But at the time, I was just by happen chance. Mostly.
It does prepare you for many things.
Yes.
Right. People, for example, who do mergers and acquisitions at big corporate firms, if you want to learn preparation for that, they will tell you become a litigator first. Right, because of how quickly things happen.
So as you sit here now, well into your career, is there any piece of advice that you would have given your younger self?
I give this advice to all of the young people who come through the office, and it's up to them if they want to follow it. But I think a lot of attorneys will learn by osmosis. So as things come to them in terms of the opportunities, that's when they start preparing for it. And as much as I think I probably worked hard in my first 2 or 3 years to prepare myself, when you're a young attorney, you have to read the rules over and over again. You have to learn in advance, so when the opportunities come up and someone brings up a topic, you can say you understand it. So an example right now, if you ask a lot of younger lawyers and even some mid-level litigators, even in trucking, they don't understand truly what the reptile theory is. They've heard of it,
Right.
but if somebody walked up to them who was a client or called another lawyer and said, we have an issue, they wouldn't really understand, A, how it's done, B, how to prepare a witness for it, and C, what are the issues that are going to specifically come out. And if
Yeah.
you don't have a working understanding of that,
Right.
you're not going to be somebody that a client has confidence in for
Right.
handling certain level and certain types of cases.
Yeah, and you certainly see reptile theory come in a lot of these trucking cases, right? Because we hit their large exposure, the risks are high, and we're seeing all these giant nuclear verdicts, and I was just talking about this with someone else too, that there was just that $1 billion verdict in Florida, and what do you think the defense bar could do differently to help combat these nuclear verdicts that we're seeing?
I think it's going to be a challenge. So one of the things yesterday that they had the panel for the Young Lawyers Association, and they had a jury consultant, and there was talk about, well, who are the jurors who are going to be sitting on panels? And I think that the research is that the millennial generation, for example, there's a belief that the numbers that they are used to seeing are astronomical.
Right.
I have an 18-year-old who's a freshman in college, and all he knows is that there are athletes who are making millions of dollars who aren't even very good. And so reducing and explaining the value of a dollar. But I think that the reverse reptile is probably the most important thing. It's every single thing that can be used that can potentially demonstrate or undermine the credibility of a plaintiff or their experts, which has been part of some of the subjects, is probably going to have to be the continued and main focus.
Right.
I think you've probably seen, so we had a case in Illinois where when the jury heard about the background of the truck driver, he was driving on a suspended license, he had a felony, prior suspensions, every bad fact that you can imagine. But they found him 100% liable, even though he was struck by a Jeep going the wrong way on the highway. And every single case we have now, they want to see the qualification file, the drivers, to look for any little thing. Right. And I don't think there's a good answer yet, but one of the things that the appellate court found significant, this driver worked for 7 companies in 10 years. That's actually better than average. The turnover
Really?
rate's 105%.
Wow.
For truck drivers. And that has to be communicated, right? Whether you want to introduce that, right? I think they said yesterday it's the trucking companies versus the drivers that people have a problem with. But I don't think that there is a clear answer right now to, again, other than really attacking the credibility of every single element of damages and liability. I think the electronic logs are going to help immensely because eliminating that is one of the 4 bad issues. I think it's been much easier to address logs and issues as to fatigue or impairment through being tired. With logs, every driver's logs are now fine as long as they're preserved.
Yeah. So, with COVID, we're seeing this, driver shortage. How do you think that's, going to impact the claims in the overall trucking industry as we have just so much less trucks on the road and less people to drive them?
And we have the need for more drivers, especially through companies that are making daily deliveries, right? There was a time, I think, during the pandemic that I was getting some type of delivery once or twice a day.
don't you sometimes wonder about that? Like, can you consolidate? Like, why do you have to come to my house multiple times? Is there some sort of communication that you can bring all these boxes at the same time?
Right. Is there some way to get it organized?
Maybe I can get this more efficient for you.
But not if you want to actually get it delivered within 4 hours through one of the specific companies. But I think, I've been practicing for 30 years, and for at least 20 years, there have been some type of discussion about the potential shortage or future shortfall of drivers, right? And in fact, they said most recently, because of going from written logs to electronic logs, it would get rid of some of the drivers who just weren't going to be compliant with that.
Yeah.
And that would make it a problem. I think if there was a way to have more drivers who are on dedicated routes, especially for the bigger companies, where they go from point A to point B and can be home a few days a week, even if they're gone for 2 days.
Right.
It's easier on home life because a driver's not away for a week or two, and it will be more. It would be a more attractive option for younger people to go work in
get
trucking.
more people in. Yeah.
But benefits, salary, it's always been an issue.
Right. And then there's certainly incentive to be a longer haul driver because of the overtime. And the pay can be higher.
Right.
So it's hard.
Right. But in the meantime, some of the companies that they're either driving locally or regionally where they can be home, if they're providing good benefits, I think that's very attractive to drivers.
So I'm going to shift gears a little bit. As I would call a seasoned attorney, you've been practicing for 35 years.
30 years.
30 years.
30 years in November.
So you have, you obviously probably have younger associates working for you. And what advice would you give them when they have to deal with like unruly or plaintiffs' counsel that just make their lives difficult? What would you tell them to be like, this is how you keep your cool or not let them ruffle your feathers?
It's a good question because I have seen attorneys who, when they are addressed that way by either attorneys on the opposite side or sometimes judges, because of their inexperience or because they maybe just appear young, or based on their demographics, something about how they look. And it will certainly undermine their confidence. And so the first thing is to always pause before you react. And if someone else raises their voice, to be confident and stern, but you don't have to raise your voice back.
Right.
People who maintain a level of composure will demonstrate to the other side that they're not getting a rise out of you.
Yeah.
And I think this is consistent with something that we see at depositions, where one thing I'll tell a witness that I'm preparing is if the attorney for the other side raises their voice, they may just be trying to get them angry, because when people get angry, they say sometimes stupid or inaccurate things.
Yes.
And so whether it's an attorney who is younger, who is being challenged, or a witness, if they can maintain their composure and show that they're not going to be flustered by it, they may or may not get a little bit more respect.
Yeah.
Some attorneys on the other side, and there's defense attorneys like this as well, who no matter what you say or how you act, they're still going to talk down to you.
Right.
But if you maintain your composure, and you can always defer responding, and then 2 or 3 times where we've talked about this with younger associates, said, well, what's a better way to respond to that, and what would you like to say?
Right.
Once you know what you'd like to say, you can always put off the conversation for a week or a month. I've also, with some attorneys that will say things and then perhaps take things out of context or misstate or misrepresent something, I myself have said, well, we could just have every call with a court reporter from now on if you'd like to do that.
Right.
And then after that, sometimes
they calm down a little bit.
The attorneys will be very careful about what they're saying, right? You
Yeah.
can't record the conversation without them knowing. But if it's a big enough case, if that's how they have to do it to make sure things aren't being misstated. Because I think a lot of times younger attorneys feel like older attorneys are saying that they agreed to do something,
Right.
and that the judge is always going to believe what the older attorney said, whether they're
Yeah.
a plaintiff or a co-defendant.
And I remember, being a very new attorney and always feeling like I was getting tricked. And like
Right.
they were, and a lot of times they were probably doing that
Right.
because I didn't know any better at the time. So I would overthink everything I was doing to make sure they weren't trying to, pull a fast one or pull the wool over my eyes.
Sure. Not responding or reacting instinctively.
Mm-hmm.
Reptile. Right?
Yes.
Take your time before answering the question and think about it. But that applies to everybody, and there isn't any reason why, unless you're in an emergent situation, that you can't say, well, let me think about these different issues and then decide how you want to respond. Because really what you want to do is anticipate what the next argument is going to be made,
Right.
So that you can articulate it. And also then confirming it. I mean, younger attorneys, everybody should do this, but young attorneys should make sure that they are documenting
Right.
accurately, making sure not, one of the problems with email is that people type an email
Mm-hmm.
and they send it off and they haven't really thought about it and how it comes off. Whereas you don't know what's being communicated versus what you intended to communicate,
Yeah.
right? I mean, that's one of the
Exactly.
dangers of sending an email too quickly. So I will tell younger associates sometimes when they get a nasty email, when you type your response out, don't put anything in the line where you have
The two,
the
yeah.
recipient.
Yeah.
Right? Hold off and save it. You
Mhm.
won't accidentally send it. And then think about your response and wait a day to read it over again and see how it reads to yourself.
Yeah, that is the exact piece of advice I got when I was a new attorney, and I think partner walked in my office, saw me like banging away at my keyboard, and he's like, "Hold up, you need to table that for 24 hours. You need a cool off period. You can't just fire that off." And it's the best piece of advice because it was true. I was angry. I was pounding at my keyboard, and I'm glad I didn't send whatever I was going to send out and waited on it because you're
Right.
much clearer the next day.
And you can let the other side know then that they can get a rise out of you.
Right.
Right, which isn't fair, and some people maybe want to show that passionate side, and they don't care
Yeah.
about holding back. But it depends if that's what the image that you want to portray
Right.
versus what is just coming out.
Yeah. Well, thank you so much for sitting down with us and being our second guinea pig.
Thank you. I
appreciate
talked
it.
too much.
No, you did
but
not.
it was enjoyable to talk about it.
Never talk too much.
Well, good luck. Enjoy the rest of your time.
Thank you. You too.